Good afternoon, ladies and gentlemen. Welcome to the webinar, Something for Everyone in the Fall 2018 Release, Explore Master Agreements and Task Orders, Instructions for Bidders, Proposal Request, Joint Venture Agreement, Architect-Consultant Agreement for Special Services, and Architect's Field Report, brought to you by AIA Contract Documents. This presentation is protected by U.S. and international copyright laws. You will receive the PowerPoint along with the recording by tomorrow. So please give us a one-day turnaround. So you will receive the materials, but of course reproduction without written permission is prohibited. This program is also registered with the AIA Continuing Education System for continuing professional learning units. When you registered for the course, you did enter your AIA member number if applicable. We'll use that data to report your credit within 2 weeks. So you will at that time see the learning units reflected on your online transcript if you indicated the AIA member number. Again, please give us a 2-week turnaround for reporting credit. Here are the learning objectives for today's course. I'm not going to go through them, but again, you're going to learn about the new and revised documents that are part of our Fall 2018 release, including the documents that are on this titled slide. And with that, I'm going to present or introduce our presenters today. For our presentation, we will be hearing from my colleagues, Colleen Telling, Esquire. Colleen is Manager and Counsel with AIA Contract Documents. She'll be joined by Michael Bamba, Esquire. He is Director and Counsel with our AIA Contract Documents content team. So with that, I'd like to welcome our presenters and turn it over to Colleen.
Well, thank you, Hasti, and good afternoon, everyone. We're happy you can join us for the next hour as we discuss what's new in the 2018 documents. Just to let you know, this presentation is for contractors and architects, so we'll be talking about agreements and forms related to both. The first document we'll discuss is the new contractor, subcontractor, master agreement, and work order. But before we do, I want to explain what master agreements are. So a master agreement is used when one party hires another to complete the same type of work on multiple projects. Essentially, you're using a master agreement for repeat business. The benefit of using a master agreement is that because both parties will be contracting with each other so much, they can execute one agreement, i.e. the master agreement, that contains their standard terms and conditions, which will apply across all of their projects, rather than negotiating and executing a new contract for each project. So examples of these standard terms and conditions are general responsibilities of the parties, how claims and disputes will be resolved, how termination of the agreement will be handled, issuing payment, and insurance coverage. Now, it's just as important to note what are not standard terms and conditions in a master agreement, and these include the scope of work or services, dates of commencement and substantial completion, and terms that differ from or are in addition to the master agreement, such as compensation and insurance. These items are found in a task order. And that brings us to the question of what is a task order? This is a general heading that encompasses both work orders and service orders. In AIA's agreements, work orders are used when a contractor or subcontractor performs work, and service orders are used when an architect or consultant performs services. Task orders are not executed until the parties sign a master agreement. And know that a contract is only formed when both a master agreement and a task order are executed. 2014 was the first time that AIA published master agreements and task orders, and they can be categorized into three types. Those between owners and contractors, which is the A series listed here, and includes a special exhibit for determining cost of the work. Those between owners and architects, which are the B series, and those between architects and consultants, or the C series. The 2014 master agreements and task orders have all been updated per the 2017 revisions and are also part of our fall 2018 release. Now, the 2014 documents were based on 2007 language, so it's advisable to update to the 2018 versions. However, if you're still using the 2014 agreements, they can be finalized through April 30th, 2020. And with the fall 2018 release, AIA now offers a fourth master agreement, which is the A421, master between contractor and sub, where work is provided under multiple work orders. Like other master agreements, A421 is not a standalone agreement, but pairs with A422 work order. Each master agreement and task order is based on an existing AIA agreement, and in this case, A421 and 22 base their overall content and structure on the widely used A401 2017, which is the contractor sub agreement. Now, both A421 and 22 also contain elements of the other master agreements and task orders for consistency. And the fourth point here, A421 is written for contractors who will hire the same sub for many projects, whether they involve the same or different owners. So I want to highlight the most important provisions to know in A421. The first is that the master agreement identifies the representatives who are authorized to act for the contractor and subcontractor. These two individuals are the points of contact for anything related to terms and conditions in the master. The second point to understand is the distinction between subcontract documents and the subcontract. As listed on the slide, each of the following is a subcontract document: the master agreement, the work order and its enumerated documents, the prime contract between owner and contractor and all of its enumerated documents, drawings, specifications and addenda, and change orders. Together, the subcontract documents form the subcontract. And if you're familiar with A401, you'll recognize these terms. The only difference here is that the master agreement and work order are additional types of subcontract documents. Regarding any conflicts in the agreements, where a provision of the prime contract is inconsistent with the master agreement, the master governs. And as between the master agreement and a work order, terms of the work order govern. So essentially, the lower level, more specific agreement controls. By incorporating the prime contract as a subcontract document, the terms and conditions that the owner and contractor agreed to flow down to the contractor and subcontractor. An example of this is in the Mutual Rights and Responsibilities article. It provides that obligations and responsibilities of the owner and contractor in the prime contract extend to the contractor and subcontractor in the master agreement. Now, the heart of this provision is that so long as the contractor performs the work according to design, the owner will make timely payments. If this doesn't happen, then each party has rights, such as stopping work or terminating the agreement, which in turn flow down to the contractor and sub. If the subcontractor defaults or neglects to carry out work and fails to correct it, the remedy is that the contractor can correct the work and then withhold the reasonable cost from the subcontractor's payment. When the contractor and sub have a dispute involving the contractor and the owner, they're to follow the dispute resolution in the prime contract. When the dispute does not involve the contractor and owner, they proceed to mediation. And if the dispute isn't resolved through mediation, then the contractor and sub proceed to binding dispute resolution, which is either arbitration, litigation, or another form that they select. And Article 11 addresses insurance and specifies the type that the subcontractor must carry. Additional coverages for specific projects will be set forth in the work order. The master agreement includes the updated liquidated damages provision from A401-2017, which states that they are set forth in the prime contract. Previously, LDs were in the contractor-sub agreement. A421 also states that a subcontractor will only be required to provide professional design services when the subcontract documents require it. And when they do, the contractor is to provide the performance and design criteria that it received under the prime contract. The sub is entitled to rely on the accuracy of that design criteria, and the contractor, in turn, is entitled to rely on the accuracy of the design professional services. The termination article also comes from A401, and an important provision there is that when the owner terminates the prime for its convenience, the subcontractor is entitled to receive payment for work that it properly executed. Lastly, the payment and retainage provisions read just like A401. For example, the default period covered by each pay-app is 1 calendar month ending on the last day of the month, but the parties can tailor this differently in the work order. After signing A421, contractors can issue scopes of work for multiple projects to their subcontractors by executing the A421. To give you a general overview, the work order specifies the scope of work, subcontract time and sum, payment and retainage terms that differ from the master, alternative or additional insurance requirements, bond requirements, and party representatives to the work order. Each work order requires a precise description of the subcontractor's scope of work. Now for this, it's appropriate to reference drawings, spec sections, pages of addenda, change orders, and any accepted alternates. The work order contains a checkbox system to establish the date of commencement of the subcontractor's work. The subcontract sum is to be entered into the work order as well. And within this category, the parties can identify alternates, unit prices, and allowances. When there are multiple owners, the period covered by each pay-app may vary from the default in the master agreement. So the payment section allows the contractor and sub to insert different dates. Also, retainage terms that differ from the master can be specified in the work order. Where the contractor is required to provide insurance other than or in addition to what is in the master, the parties can insert the type and limits here in the work order. The penal sum of payments and performance bonds can also be provided here. Also, the individuals authorized to represent the parties with respect to a particular work order may be the same individual as that identified in the master. So those are the details of AIA's new contractor-subcontractor master agreement and work order. And now we're going to cover some updates to the other master agreements and task orders, beginning with A121, the owner-contractor master. Its content is derived from A104, the owner-contractor agreement based on a stipulated sum. It pairs with work order A221, and where payment is based on the cost of the work plus a fee, Exhibit A is to be used. Finally, the A201 general conditions are built into A121, meaning that A201 is not a separately attached document, but most of its terms and conditions are written into this master agreement. Similar to what's provided in A201, the contractor may request evidence that the owner has financing for the project. If the owner fails to provide this, the contractor is not required to commence construction. Now, when the contractor defaults or neglects to carry out the work, the owner has the option of correcting the work, and then the architect can withhold or nullify a pay-app to reimburse the owner. If the contractor disagrees with the withholding, it can then make a claim. You may recognize that this is similar to the contractor's remedy we discussed earlier if the subcontractor defaults. A new section recognizes that the contractor may be required to hire design professionals if the contract documents require it. So just like the provision written into the contractor sub-master agreement, the contractor is permitted to rely on the performance and design criteria from the owner and architect, and they in turn can rely on the design professional services. Language regarding preparing a control estimate was in Exhibit A, determination of the cost of the work, but it was moved to A121 because it was considered out of place in that exhibit. So Exhibit A now includes only those provisions for determining the cost of the work and not for preparing control estimates. A new provision requires the contractor to defend and indemnify the owner for any lien or other claim that a subcontractor may make for payment, and this is provided the owner has fulfilled its obligations under the contract, which basically means providing information when it's requested and making timely payments. The insurance section has been expanded and modified to track insurance requirements from the 2017 owner-contractor agreement. The contract termination provision was modified to establish a termination fee that's payable if the owner terminates the contractor for the owner's convenience. Costs payable to the contractor in this situation would include costs to terminate its subcontract. Regarding claims and disputes, revisions clarify that claims occurring before the correction period ends are subject to a 21-day notice period and an initial decision by the architect. Language is also added, consistent with A201, requiring the contractor's continuing performance pending resolution of the claim. As I mentioned, A221 is the work order that pairs with A121, Owner-Contractor Master Agreement. It too is based on A104, 2017. It fits with various payment schemes, such as stipulated sum and cost of the work with or without a guaranteed maximum price, or GMP. And as we saw with the new A422 work order, A221 also establishes contract time, sum, additional insurance and bond requirements, representatives for the work order, and it enumerates all contract documents. Date of commencement is to be the date of the work order or a date set forth in a notice to proceed. In the contract sum article, parties are able to check a box beside a method that they'll use to determine the contract sum, and the options are listed here on the screen. Also addressed within the contract sum article are liquidated damages, where the owner can provide the amount and any conditions for LDs. Just a reminder that liquidated damages are not a penalty, but they must be an actual or reasonable estimate of the owner's loss in the event that construction is not completed on time. Now, when there are multiple projects, the period and dates of the pay-apps may vary. When they do, the owner and contractor can specify the time period covered by each pay-app if it differs from the master agreement. And the same thing is true for retainage in the work order. The insurance provision is fairly short, but it provides for types and limits that differ from or are in addition to those in the master. And where the contractor is required to provide payments and performance bonds, the penal sum of each can be designated in the work order. We'll turn now to B121, which is the Owner-Architect Master Agreement. It has been updated pursuant to changes made in B104-2017, which is the abbreviated Owner-Architect Agreement. B121 is coordinated with B221, the service order. B121 provides common terms, which are seen here, that apply to each service order. Again, use of B121 and B221 creates a contract which is referred to as the service agreement. And in the owner-contractor realm, the equivalent would be the subcontract. So what changed in B121? Well, one change concerned whether to follow the master agreement or service order when there's a conflict between terms and conditions. So consistent with A421, B121 now provides that terms of the service order will take precedence. A second change concerned insurance. That article consolidated commercial general liability, auto, workers' comp, and professional liability into one section and requests limits for the architect to carry. A third change was made to the termination article. When the owner terminates the contract for its convenience, the architect is entitled to cost for terminating its consultant's agreements. Again, sort of the same thing as with the owner-contractor and contractor-sub agreement. Here we've added a fill point for a termination fee, as well as a licensing fee if the owner continues to use the architect's instruments of service. The licensing fee was already in the 2014 master agreement as its own section, but it's been moved here to the termination topic. The third change is that the service agreement will terminate 1 year from the date of substantial completion. B221-2018 is the owner-architect service order that accompanies B121. It stipulates the initial information, scope of services, insurance, and compensation. In the service order, we added a new article to address the architect's scope of services, which is divided into basic and additional services. This parallels the change that was made in B104. So I would note here that additional services in the service order are in addition to or modify those in the B121 master agreement. Changes are also made to the compensation provision for basic services. In particular, it contains subcategories for stipulated sum, percentage basis, and another category which can be used for hourly billing rates. The insurance article has been modified to allow the parties to specify types and limits that differ from or are in addition to the master agreement. Turning now to C421, this master agreement between architect and consultant is based on C401-2017, which is a standard form of agreement between architect and consultant. C421 incorporates an owner-architect agreement, otherwise known as the prime agreement. And C421 is to be used with the C422 service order. The first change to C421 was that we added a mutual rights and responsibilities provision. This did not exist in the 2014 version. And as we discussed with the new A421 contractor sub-master agreement, obligations and responsibilities that the owner and contractor have with each other in the prime agreement flow down to the architect and consultant in the master agreement. New language was also added to clarify that the consultant's duty to indemnify the architect does not include the additional duty to defend the architect. That was the intended meaning of the 2014 version, but we just clarified that a bit here. And a reciprocal obligation was added for the architect. Another provision added to keep C421 consistent with C401 is that when the architect and consultant have a dispute involving the owner, it's to be resolved according to the binding dispute resolution method in the prime agreement. This is an area where the mutual rights and responsibilities provision flows down because the consultant is only entitled to the same relief from the architect that the architect is entitled to recover from the owner under the prime. Next, the parties can identify a termination fee and licensing fee that the architect would pay the consultant if the architect is terminated for any reason besides the consultant's fault. Not many changes were made to the C422 consultant work order. We reordered a couple provisions, so insurance is listed later in the document, which is consistent with other task orders. The insurance provision requires, again, listing insurance terms that differ from the master agreement. And we added an article for party representatives at the end, which is also consistent with the other work orders. Transitioning now to the A701-2018, the instructions to bidders form is for competitively bid projects, whether they're public or private. The caveat for public projects is there should be coordination with federal, state, and local laws, as those may impose other requirements. Information from G612, which is the owner's instructions to the architect, specifically Part B, should be used in completing A701. That document contains questions for the owner with regard to insurance and bonds for A701, the amount of any bid security, where copies of the bidding documents are available, and the date and time for receipt of bids. The most noticeable update to A701 is that it's no longer a static form, but it now requires the architect to complete a handful of fill points. A701 no longer acknowledges paper bids only, but it now accounts for electronic bids. If electronic is selected, there's a prompt to specify availability, which could be by email, website, a host site or platform, or another method. We also added a section stating that the bidder is to refer to the owner-contractor agreement, which is part of the proposed contract documents, to determine if there are liquidated damages provisions. So in other words, if LDs exist, they're not a default provision in the instructions to bidders. A new addition to the bid security section is that if no contract has been awarded or a bidder has not been notified of acceptance of its bid, then a bidder may withdraw its bid and request return of its security beginning a certain number of days after the bid opening. That time frame is one of the fill points for the architect to complete. Another new provision is that when a bidder discovers a clerical error in its bid, after the designated date and time for receipt of bids, the bidder may withdraw within 2 days after bid opening. In order to withdraw its bid, a bidder must provide evidence of that clerical error to the architect's reasonable satisfaction. Yet another new provision is that a bidder agrees to incur all costs associated with preparing its bid. The clarification to the substitution section is that we introduced a heading for the substitution process. We added that requests for substitution are to be made in the same manner that requests for clarifications and interpretations are submitted to the architect. Additionally, we added a provision stating that if the bidding documents provide a substitution request form, then that's how bidders are to submit substitution requests. One other clarification was made consistent with the 2017 updates, and that is that the bidder must provide proof of its legal authority to work in the jurisdiction where the project is located, and this must be provided as part of the bid package. Another revision was to update old language from awarding the contract to the lowest bidder to the lowest responsive and responsible bidder, which is consistent with standard industry language. A fourth revision concerns the bidder requesting evidence of the owner's financial resources for the project. Previous language said that upon the bidder's request, and this is the bidder to whom award of the contract is under consideration, the owner must provide evidence of its financial arrangements 7 days before the date the bidder can withdraw its bid. So that left an unknown as to when the bidder could submit its request. And a worst case scenario was if the bidder requested on the 6th day, the owner had just 1 day to provide documentation before the bidder could withdraw. So we now state that the bidder has to request this information in writing 14 days before the date for withdrawal of bids expires. And this way, the owner has 7 days to provide that evidence, and there's another 7 days until expiration of the time for withdrawal of bids. So if reasonable evidence is not furnished within that time, then the bidder is not obligated to execute the owner-contractor agreement. A final change to A701 is that it no longer defaults to only naming an owner-contractor agreement at the end. Instead, it enumerates all proposed contract documents. Moving on to G709, the proposal request form. The first thing to know is that the title has been shortened from Work Changes Proposal Request. This was done to reflect current industry usage. This form is used to obtain quotes for potential changes in the work. So it's not a change order, it's just a request for a price for work that may change or may be added to or deleted from the project. The header block requiring general information about the project has been consolidated, so it no longer takes up half a page. Also, the architect is the party who prepares and transmits the form to the contractor. The 2001 version of this form required that the architect provide a written description of the work, and the 2018 version expounds on this and prompts the architect to attach or reference exhibits, which may include drawings. Lastly, the signature line was removed. However, the line for the architect to print its name has been retained. The reason the signature line was removed was because this is not an official directive to do any work. The request and issuance of the proposal request are no less official without the signature line. And now I'd like to turn the presentation over to Mike, who will discuss the joint venture agreement.
Thank you, Colleen. Appreciate it. So we're going to be going over the joint venture agreement, and this document hadn't been updated since 1993, which means it's about 25 years old. So it's older than most recent college graduates. So it was about time that we took a look at it and updated it. So our C101 2018 joint venture agreement is an agreement between two or more design professionals to provide services on a project. So you wouldn't use it in a scenario where an architect and a contractor are going to be entering into a joint venture to, say, pursue a design build job. It's for when you have two design professionals that are coming together to go after and perform services on a project. The first edition, the 1993 version, was a pretty flexible document in terms of form and how you put the joint venture together, which I suppose there's value in flexibility. The only problem was that it was so flexible that it was kind of confusing. It wasn't clear what form the joint venture should take, and if you made certain decisions within the flexibility of the form, what impact that had elsewhere. So our goal for this round was to create a more useful standard form that could be a starting point for establishing a joint venture, and to try to provide a little bit more of a solid framework for users to use this document and to structure their joint venture. Sort of the assumption we made when we were drafting this document is that it would be most ideal for those firms that don't have their own in-house counsel and are interested in pursuing a joint venture relationship and need a starting point to go from. So we'll go into a little more details of the agreement. We don't have a ton of time, so it'll be a somewhat cursory review. But just to start things off, I did want to go over what a joint venture is. A joint venture is an association of two or more parties engaged for a single business enterprise. A joint venture is essentially a partnership. It's a general partnership. But the big difference between a general partnership and a joint venture is that the joint venture is typically for a limited duration. In the context of the design world, it's usually for a specific project. So, it is like a partnership in the sense that it can be formed in any number of ways, even a handshake. I don't recommend that, but it is possible if you could form a partnership just based on your course of action. The partnerships and joint ventures are not statutory entities for the most part, like a corporation is, or an LLC, or anything of that nature, which is an entity created by statute, and you have certain requirements you have to meet in order to form one. Joint ventures can kind of just happen, just like a general partnership can. I wouldn't recommend just letting them happen. I suggest you have some sort of an agreement in place to govern your relationship with the joint venture parties. Because a joint venture is essentially a partnership, you have to also be aware that in a joint venture, each of the parties has joint and several liability. I'm sure many of you have heard about joint and several liability and know that it's bad and should be avoided, but we'll try to get a little bit better understanding of why that's the case right now, because it's something you need to understand if you're going to be entering into a joint venture relationship with someone. Joint and several liability is essentially a characteristic, default characteristic of a partnership in joint ventures. And essentially it means that whatever liabilities the joint venture has, so if there's a claim against it or it owes money to someone, each of the parties to the joint venture can be held 100% responsible for that claim or liability to the third party. So if you're a joint venture and you're providing design services on a project, and we'll take for an example, let's just say that there's two architecture firms have gotten together and formed a joint venture, and each one has a very discrete portion of the project that they're performing on. If architect number two in their portion of the project performs negligently, and that results in a claim from the client, as the client is concerned, their claim is against the joint venture, and architect 1 and 2 are both responsible as far as they're concerned, because the joint venture is responsible. So if, for example, the architect 2, who is the one who actually was negligent, turns out not to be able to pay the claim, maybe it doesn't have insurance any longer, or something, or has gone under and is no longer a viable entity. Regardless of the fact that architect 2 was the party that was the reason for the claim, architect 1 would still be responsible for the full amount of the claim to the owner. So it's different than when you have a client, an architect consultant arrangement where you can pass that liability on to your consultants or something like that. So it's just something to be mindful of if you are going to be going the joint venture route. That joint and several liability will attach, and it can be problematic because it's not tied to actual fault, which for some insurance providers is an issue. So why would you even bother entering into a joint venture? Well, there's lots of reasons, some of which are that it might be required by the owner. In some jurisdictions, if you're doing public work, there might be a statutory obligation for a joint venture. It may be that the type of project you're involved with, there's an extremely important or large engineering portion of the project, and so the owner may want both of its prime designers to be at the same level in essentially a direct contract with the owner. So it may require the architect and engineer to form a joint venture for the project. Or sometimes if you're if there's a minority business entity ownership requirements for a project, sometimes you'll see a joint venture formed to meet those requirements. There also may be a strategic decision on the part of your firm. If you have if your firm has a particular area of expertise, but the project calls for something beyond your particular expertise, and there's another firm out there that you know of that has complementary specialties, you may want to form a joint venture to make yourself more attractive when you're going after that project from the owner's perspective. So they might actually be more likely to give you the job if you're a joint venture. And also, too, if you're a foreign, quote unquote, foreign firm, if you're coming from another jurisdiction, and you may want a joint venture with a local architect who's got more connections in the area and is more familiar with the area's practice. It may, again, make you more marketable to get a job. So there's a number of different reasons. Well, I don't think anybody would say a joint venture is the ideal way to provide professional services. Nevertheless, they're out there, and there may be valid reasons that you would have to enter into them. So it's good to understand what you're getting into, and we hope that the new C101 2018 document will give you a good framework for putting that type of a project together, that type of relationship together. Now, I said that let me jump ahead here, sorry. So the way our C101 is structured is it's intended to provide the governance structure for the joint venture. Now, we just talked about joint and several liability to the client, but what the C101 does is try to take that joint and several liability that the joint venture owes to the owner and deal with it internally on a comparative fault basis, and we'll go over that later. So while the joint venture outwardly has joint and several liability to its client and any third parties, internally we try to allocate responsibility on a more traditional comparative fault basis. It's also important to understand that the C101 is not the design contract. The C101 puts the joint venture together and it describes how the joint venture will work. The expectation is that the joint venture itself will enter into a separate design agreement with the client, and that will be the design contract. So when we were drafting the C101, we had made a set of assumptions, and I'll go over them briefly here. Like I said, the old C101 was pretty loose in terms of its structure, and we think that may have been one of its shortcomings. So this time around, we tried to be specific on structure, which required us to make certain drafting principles. And it's important to go over these because some of these principles or assumptions may not fit the exact circumstances your project has. And if that is the case, you need to be aware of these because there may need to be some changes made to the standard language. So as I said earlier, it's intended for design professionals only, maybe an architect getting together, or an architect in an engineering firm, something like that. And it can be for more than two parties, although I think in most instances you're going to have a two-party relationship. It's a project-specific relationship. It's intended to be, you're pursuing one project. If you don't get the project, the joint venture goes away. If you do get the project, once the project is over, the joint venture goes away. You don't have an ongoing partnership relationship, and it doesn't exist on anything outside of this specific project. While the joint venture will sign the contract with the client, the expectation is that the parties will also. And the primary reason for that is practical. If the parties don't sign, then you have to go through a process of granting one of the parties the right to sign on behalf of the joint venture and make decisions on the behalf of the joint venture in the design contract. So you don't have to go through a whole encumbrance process or create a power of attorney. You can just have all the parties sign the agreement. We also assumed that the joint venture agreement was going to be is going to sign an agreement with the client on a lump sum basis. The reason we went with a lump sum is because it makes disbursements within the joint venture a lot simpler. If you're billing based on the work actually performed, it's a little more complicated based on which joint venture partner was performing what at which time, and from an accounting standpoint, it's a lot more difficult to trace. So we thought, for a standard form agreement, the best approach was a lump sum basis. We also assumed that the joint venture is not going to be retaining consultants directly, meaning that the joint venture isn't going to go out and hire the engineers. The actual parties to the joint venture are going to do that. And the reason we did that is because it's a lot easier to track liability or to keep that division of liability between the partners for our internal approach to dealing with liability. So if you had the joint venture hire a consultant, and that consultant is the one who was the cause of a claim, how do you divvy up responsibility for that amongst the various joint venturers? It could cause a problem on the insurance side as well. So we decided that it would be best to maintain those discrete lines of responsibility. So if each party will be responsible for retaining particular consultants, and so if that consultant messes up, the liability flows up to that joint venture party. Now, again, going outside of the joint venture to the client, they don't care. It's just going to come back on the joint venture itself. Parties might have different interests, but that means all decisions are going to be unanimous. And as I mentioned, the parties are going to share liability on a fault basis within the entity. So we have a policy board. One party equals one representative on the policy board. All decisions are unanimous. Some of the other things that the policy board will have to do are they'll have to hire a project director. The project director is kind of responsible for overseeing the day-to-day operations of the project itself. Identify a project accountant. there may be some accounting and tax obligations that the joint venture takes on, and so it'll be important for the project accountant to take care of those things. So if the policy board can't reach a unanimous decision, you kind of have a problem. But what we didn't want to do was require the parties to go through a whole long dispute resolution process. Because if you're going through a long dispute resolution process in a joint venture, you're in serious trouble. I mean, the joint venture can't act. It needs to perform on its design agreement with the client. And if the policy board is stuck and can't make a decision, the joint venture is paralyzed. So what we tried to do was create a secondary group that would review those disputes, a dispute resolution board. And so the dispute resolution board, again, is one party gets one representative, but the representative is supposed to be someone from a higher level or senior management within the parties, so that they would be in a position to resolve a dispute quickly, to hopefully get over whatever the problem is and keep the project going. Now, if that can't happen, if they can't reach a decision, then unresolved disputes are going to go to mediation, and then whatever binding dispute resolution you've chosen, litigation or arbitration. But quite honestly, in a joint venture, if you're getting to that point, the wheels are probably coming off. Quickly, we'll go over the indemnification provisions. Again, the purpose of them is to address the parties' joint and several liability obligations outside of the joint venture. And the goal is to allocate that liability among the parties on a comparative fault basis. So joint venture owes 100% of liability to a client, and then we're going to divvy it up within the joint venture. So if it's a claim based on professional negligence, each party indemnifies the other for claims to the extent of that party's fault. So it's a comparative negligence. So if one party was 10% fault and the other one was 90% at fault, that is how you would divvy up responsibility for the claim within each other, within the joint venture. Now, if you have a claim that's unrelated to professional negligence, which is possible, the indemnity, again, is just, it's to the extent that it arises from a particular party's acts or omissions. Now, obviously, this is not something that will be easy to work out, but it's better than getting pinned with 100% of the obligation to the client. So we've attempted to allocate that based on some sort of comparable fault. The only thing, and this is again one of the dangers of a joint venture, is that this is only internal. So let's say your joint venture party can't. It may be required to indemnify you based on its fault, but if it can't, the other parties still have an obligation to the client to pay the 100% of the claim. So these indemnifications are only as good as the other party. So when you're entering into a joint venture, you want to make sure that you know and trust the party you're getting into. As I said, joint ventures are really not that favored in the industry. It's not the best way to provide your services. They are laden with complex relationships, and joint and several liability is a headache no matter how you look at it. It's a complicated agreement, and which sort of required us to make certain drafting assumptions and principles. But if you deviate from those, pay attention, because you're going to possibly have to revise our standard language. There's also insurance concerns. I know that a number of carriers will cover you for professional liability claims that you pick up as a result of being a part of a joint venture, even if it was the joint venture party who really was the actor. But there are certainly going to be policies out there that will exclude joint venture liability. So you definitely need to seek consultation from experts before you're getting involved in any joint ventures. You should talk to your insurance carrier. You should also probably talk to an attorney in the area to make sure that there's nothing in particular that needs to be changed for your local jurisdiction. So that is a quick overview of the C-101. If you have any questions at the end, you're welcome to email us. But for now, I'm going to turn it back over to Colleen to finish up this program.
Great. Well, thank you, Mike. For those architects who've hired consultants for special services, you may recognize this next document better as C-727. The title remained the same in this update, but it was renumbered as C402 to more appropriately classify it as an architect-consultant agreement and not a miscellaneous document. So C402 is intended for consultant services that are limited in scope or do not extend to the construction phase. Some examples are modeling, feasibility studies, spec writing, elevators, fire protection work. Now, if the parties will incorporate all terms of the prime agreement and involve the consultant in the construction phase, then C401, the standard architect-consultant agreement, should be used. That contract is also appropriate for consultants providing traditional MEP and structural engineering services. The updates to C402 are from the 2017 versions of B101 and C401. And probably the biggest change to C402 is that the previous version did not contain any flowdown. This update introduces limited flowdown for copyrights and licenses and payments. The reason for this is that the owner-architect agreement requires the architect to obtain a non-exclusive license from its consultants the same way that the architect provides a non-exclusive license to the owner for its instruments of service. So this means that the consultant and architect retain all of their rights, including copyright, for drawings, but the owner allows other project participants, namely the contractor, to use the instruments of service, such as by reproducing drawings, to construct the project. Now, if the owner were to violate that agreement, there are protections for the architect, which in turn flow down to the consultant. Regarding payments, we included a provision that the consultant shall be paid promptly after the architect is paid by the owner under the prime agreement. So the payment terms between the owner and contractor flow down to the consultant, which keeps an even and fair playing field. One update to C402 is that the consultant is to be licensed if the jurisdiction where the project is located requires it. A second update is that the agreement terminates 1 year from the date of substantial completion. And lastly, mediation was added as a condition precedent to any form of binding dispute resolution. Previously, arbitration was the only form of dispute resolution provided. But now the parties can choose from arbitration, litigation, or another method that they specify for binding dispute resolution. And the last document that we're going to discuss briefly here is the Architect's Field Report G711. So this form is used by an architect to record periodic site visits. A major change to this was that we added an italicized note below the document's title, which says that the observations in the report are made to generally reflect the progress and quality of the work. They're not meant to be exhaustive evaluations of the work. And this statement is to echo the architect's responsibilities in the B101. We remove the % complete field, as that can be difficult to quantify, and it's something that the contractor will report on its payout. We show here a couple other fields that were removed and consolidated. Attachments field is still there, but just know that that's an area where you can include photos of the project. Lastly, the architect of record does not have to sign the field report, but the individual from the architect's team who conducts the site visit and completes the form is required to sign. So that concludes our presentation about the 2018 Fall Documents release. We hope the information was helpful, and we thank you very much for your time and attention. Now I'll turn this back over to Hasti, who will tell you a little bit about our education resources.
Thank you, Mike and Colleen, for a great presentation. Just to close, I wanted to indicate that all attendees and registrants will actually receive the recording and the PowerPoint by tomorrow. So you will receive the PDF PowerPoint along with today's recording. We'll also be placing the recording on our Learn page. I encourage you to visit our Learn page as we have a plethora of education, both live and on demand, available for you to learn more about our content. If you have any questions from today's webinar or about any of these documents or our content in general, please direct them to docinfo@aiacontracts.org or 202-626-7526. We'll be happy to get answers to any of your questions. Any questions about our products and the online service, you can direct to our technical support at docstechsupport@aiacontracts.org or 1-800-942-7732. So with that, I want to again thank our presenters for taking the time to present today, and for all of our attendees, we hope you enjoyed the webinar, and we look forward to hearing from you with any questions. Thank you all.